Hello and welcome to a fresh episode on Legal Wrangle on corporate laws. Let's go to the headlines. The larger bench of the Supreme Court has held that the appeal against an international commercial arbitral award not maintainable where the tribunal has addressed all claims and counterclaims and followed procedure. APPELLATE has held that NCLT has no jurisdiction to rectify resolution plan after expiry of period for completion of corporate insolvency resolution process. Delhi High Court has held that penalty under FERA 1973 relating to restriction on payments is not sustainable solely on the basis of retracted statement. Now let's discuss the cases in the light of their background.
The issue in appeal arose from a joint venture agreement between Ravin Cables Limited and PRYSMIAN CAVI SISTEMI, which is an Italian company. The Italian company acquired 51% of the controlling stake in Ravin Cables. It was agreed between the parties that the Italian company can appoint a CEO of its choice during the early days of the integration period. When the acquisition process commenced, both the parties got embroiled in various disputes regarding the joint venture agreement, starting from the hiring policies. The matter was referred to the sole arbitrator in London, who passed the awards in favor of the Italian company and dismissed all the counterclaims of Ravin Cables. The award was then brought before the single judge of the High Court for enforcement, who found that the award must be recognized and enforced.
Since the Arbitration Act does not provide a remedy of appeal when a foreign award is recognized and enforced by a single judge of a high court, the appellants who were the shareholders in Ravin Cables appealed against a judgment under Article 136 of the Constitution. The court observed that a challenge against a foreign award under Section 48 of the Arbitration Act can only be made on three grounds. The grounds are where the arbitral tribunal is without jurisdiction, where the parties' claim or counterclaims are not taken into consideration, where the award is against the public policy of India. The Apex Court took all the facets of the award into consideration and reached a conclusion that the International Arbitral Tribunal had dealt with all the claims and counterclaims of the parties. The court observed that it often happens that the tribunal considers a particular issue as essential and answers it, which would mean that the other issues raised have been implicitly rejected. What is important is that the foreign award must be read as a whole, fairly and without nitpicking. Thus, the court dismissed the appeal and reached a conclusion that where International Arbitral Tribunal has addressed the basic issues of claim and counterclaims and rejects the counterclaim, appeal before the Apex Court cannot be filed against the recognition of the foreign arbitral award. Moving on to our next case, the APPELLATE discusses the extent of inherent powers of the NCLT and reiterates an important principle.
In this case, after the resolution plan in the insolvency process of Cosmic Ferro Alloys Limited was admitted and approved unanimously by the Committee of Creditors, the NCLT approved the plan of the resolution applicant, but at a later point modified the plan under its inherent powers. The rectification of plan was done after the application was filed by one of the resolution applicants. Thus, the issue arose was the extent of inherent powers of the NCLT.
The APPELLATE observed that since ratification of the resolution plan does not involve the question of priorities or any question of law or facts arising out of insolvency resolution or liquidation proceedings of the corporate debtor under the IBC 2016, therefore ratification is not in code. The APPELLATE categorically held that NCLT has no jurisdiction to entertain an application for ratification of resolution plan and making substantial changes in the plan after a lapse of 13 months from the completion of insolvency process. Thus, even after the approval and implementation of resolution plan on the pretext of ratification of clerical or typographical error in the order, the NCLT is barred from modifying the resolution plan under the guise of inherent powers of the tribunal. Now, in our next case, the High Court of Delhi has recently carved an important ruling on the bankability of statements made during search conducted by the Enforcement Directorate.
The issue in this case arose out of the culpability of the appellant Mr. MANAK, who was penalized for violation of Section 9 of the FERA 1973 for bringing foreign remittance in India under the Hawala network under instruction from parties in Dubai. Mr. MANAK, who runs a travel agency, was held guilty on the basis of his statement made by his employee during the search action that he was involved in receiving and distributing money in India without corresponding to proper network. What became pertinent was the fact that a day later, the statement was retracted. The appellate authority reduced the penalty from Rs 75 lakhs to Rs 7 lakhs after taking into account the retracted statement and that there was no incriminating document found during the search. Thus, the whole order of violation of FERA was passed on the basis of one retracted statement.
The High Court frowned upon the fact that the tribunal, even after acknowledging that the Special Director Appeals has accepted that there was no evidentiary value in the statement and that there was no material on record which established guilt, confirmed the penalty upon the appellant. The statement, it was observed, was made during the search and retracted on the very next day. The statement itself was found to be vague and did not name or describe any person from whom funds were received and to whom funds were distributed. Hence, the court reached a conclusion that penalty order due to contravention of Section 9 of the FERA 1973 relating to restriction on payments is not sustainable solely on the basis of statements made during the search which was later retracted. Hence, the order of the monetary penalty was set aside and the ED was directed to return the confiscated amount with interest to Mr. MANAK. With this, we wrap up this episode of Legal Wrangle, and for finding detailed head notes, you may log into www.tiolcorplaws.com. Thank you for watching.